rise. The Court of Appeals Division 1 is now in session.
You may be seated. Good morning, counsel. We are here for oral argument in case number CV18-0063, State v. MAUCELI. These proceedings are being recorded, so we'd be grateful if each of you, when you approach the podium, give us your name, the name of your client for the purposes of the recording. As you probably both know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time to use in rebuttal, but you are in charge of keeping track of your own time. The clock that you will see on the podium reflects the total you have remaining, including any amount that you may have decided to reserve. Please keep in mind we've read the briefs, we've looked at the record, we've conferenced and discussed the case, and with that, you may proceed.
Thank you, Your Honors, esteemed colleagues. I'm happy to be here to argue this. I'm honored to have this day to present to you the tragedy that is the proceedings that occurred in this case in La Paz County. Sure, they turned out all right, but for my client, I didn't introduce myself. I'm Robert Wolkin. I'm here on behalf of Nicholas MAUCELI. And I guess I'll begin my argument now. Okay. Nicholas, this case is sort of dear to my heart for the simple reason that Nicholas MAUCELI, I've known Nico for a while. He's not a good friend of mine. He hasn't been a big client in the past, but I have known him before because he works at and was the manager of a marijuana dispensary grow site in Tucson, which I've been representing since the onset. So I've known Nico, and he's worked his way up the ranks to become the full-time manager. And before that, he was a driver that delivered marijuana from the grow site to different dispensaries around town. They have a fairly substantial grow site. Nico's an avid soccer player. He plays in like 6 different teams down in Tucson. I know him because I do some administration and refereeing in those soccer leagues. So when Nico called me and said, "Hey, here's what happened to me," I couldn't believe the story. I just simply couldn't believe the story. He gets pulled over on I-10 for going 2 or 3 miles an hour over the speed limit, which later on the testimony at the hearing is that the officer says he wasn't really concerned about that. What he was concerned about was the rearview mirror radar detector that was on the front windshield just below the rearview mirror, which it turns out is perfectly legal under the statute. But so we don't even know why Nico was pulled over to begin with. There really is no accurate justification. The DPS officer isn't too much aware of what's going on. I mean, he's the one that pulls the guy over for a reason that doesn't make sense, and then testifies at the hearing. Well, the reason the money was seized is because it was over the threshold amount. You know, there is no threshold amount. I'm not aware of any threshold amount. I wish that
Mr. Wolka, perhaps we could focus your argument a little bit. It's my understanding that on appeal, the issue is whether or not your client is entitled to his attorney's fees, which is a legal issue. And the question there, really, the heart of it is this recent amendment to the statute.
Well, fine. What I'll do is just say to you that I think part and parcel of whether or not he's entitled to have attorney's fees awarded in this case is the actions of the state and what they did, because I either have to show that they intentionally harmed him, my client, or that they were grossly negligent. Well, you know, if we're talking about a general intent, the actions of the government entities, the action of the county attorney, the action of the DPS, the actions of the La Paz County Sheriff, all were abhorrent. Is the only thing I can say.
Right, but I think the question is if we assume that the state was grossly negligent, is there authority for the fee award? I think that's the question.
Is there authority? Okay. If you want, I'll address the retroactivity of the statute if that's what you want me to do. Is that what you're asking?
That's one question issue I have.
Yeah. Okay. The reliance. I think the argument on the other side that it's not retroactive stems from Boulder versus Turek, which is the statute which is the case, I believe, that allowed for the award of attorney's fees, and the issue was that going to be allowed to be retroactive from the date that it was went into effect? And the answer to that question is succinctly and simply this: that when you're talking about attorney's fees arising out of a contractual obligation, which has become a big part of the law in many years now, the real issue is when do the actions of any party attach and allow the award of attorney's fees? And the answer is from the onset. From the onset of the litigation, it's clear that that's what you're asking for, attorney's fees. And that becomes part and parcel, and so therefore it's not going to be retroactive. Because it's a substantive matter as opposed to a procedural issue. Far different from what we're talking about here. What we're talking about here is the application, I guess, of the Carver case, State versus Carver, where they were talking about whether or not they were going to allow a wife to testify against her husband, where the wife had told something to the police about what her husband said about committing a crime, a murder, I think. It was a pretty serious case. And it was determined initially that, well, you're not going to be able to, what was determined was that the state decided we're not going to prosecute this case. We're going to go get a legislative enactment. We're going to get the legislator to change the law so that this woman could testify against her husband, and they specifically tailored that law to fit the facts of this case. And then they refiled the murder complaint. Then the statute was changed to say that in cases where the wife has already told authorities about what's going on with the marital communications, we're not going to let her assert the privilege. Well, the key to that case and the key to this case is that the privilege doesn't arise. It is not an issue at the onset of the case. I assume the prosecutor is going to get up here and he's probably going to tell you, well, you can't retroactively use these statutes because this case was initiated back in 2017 before the new statute went into effect. But that's not when we asked for the attorney's fees. The statute's been changed. The statute was an abomination to begin with, and I apologize for using that word, but it was from the perspective of somebody trying to get money back from the state that they've seized. There are all sorts of procedural problems with fighting a forfeiture action, not to include the fact that you couldn't file motions to suppress, you couldn't get any procedural safeguards in that regard, and it was virtually impossible, or it was very difficult to meet the procedural hurdles, which included that you couldn't continue the case, you had to file everything timely. If you didn't get anything filed appropriately, you lose the case. The presumption, it was almost a presumption of guilt going in, or a presumption of forfeitability, because it was just a preponderance of the evidence, and many times the defendants were in a position where they couldn't defend themselves. They couldn't testify but not for reasons because they'd done anything wrong, just for reasons that they couldn't appear to have done anything wrong. If they did, they weren't going to prevail. Not the least of which was the presumption, the burden of proof. The burden of proof was a preponderance. Now in the new statute, it's now clear and convincing. The judge in this case didn't even apply that standard, but I digress. And what I want to talk to you about the retroactivity is that we didn't make our claim until the state dismissed its case. The state didn't dismiss its case until after this new statute went into effect. That's when we made our claim for attorney's fees. Perhaps the Carver case, wording in the Carver case, is the best indicator of what, when you are asking for the relief under the new statute, where the new statute has gone into effect in a case where the original pleading was filed before the statute went into effect. Carver court held, the court held that because the privilege is not asserted at the time the action is filed, but only when the testimony of the spouse is offered at a trial or hearing, and they quote, "The fair meaning of the statute is that it shall apply in trials or hearings which are held after the effective date of the act. Thus, applying the restriction of the privilege to later testimony is prospective in nature." So it's not a retroactive application at all. The Michigan Court of Appeals held the same way in State versus Clevenger, 69, Washington 2nd, 136. What the state did in this case was mean-spirited. I'm asking you to conclude, based upon everything that you've seen and heard in this case, that there was no reasonable basis, there were no reasonable inferences to be drawn from any of the facts set forth in the police reports, which is what the county attorney relied on and nothing more, that would allow you to conclude that Mr. MAUCELI had committed any crime whatsoever, especially a crime in a different state at an unknown time. There is nothing in this record that indicates that my client did anything wrong. And there are multiple occasions where the state acted without due respect for the concerns that I address here. First of all, they seized forcefully, they seized the money. Second, and let me back up a minute. Why did they seize the money? They seized the money because the officer on the scene said he smelled marijuana. Now, my client is privileged in the sense that he's allowed to have marijuana smells on his car. He delivers marijuana in his car from place to place, and he does that under the AMA, and he does that legally. Now, the officer merely asked Nico, "Do you have a marijuana card?" Well, he's referring to the card that allows you to use marijuana. My client says no. He says, "But I've got a dispensary agent card." Not only is he not interested, the officer not interested in seeing the dispensary, neither officer would even look at the dispensary agent card. And the fair conclusion, and I believe what they said at trial, at the hearing, was that they didn't even know what it was. Well, you know, there's a statute that specifically protects a dispensary agent from unlawful, improper, and unreasonable searches and seizures. I would suggest to you that the officers were not the least bit interested in protecting my client's rights. If they had looked and acknowledged the dispensary card, they would have realized that the smell of marijuana on my client's car was no reason to suspect anything or go any further. But they didn't. And then it just snowballed from there. As soon as there's money involved, now, remember, there's no marijuana in my client's car. There's nothing improper or illegal. There's just money. As soon as they saw it, they weren't going to let it go.
Mr. Wilkins, so just so I understand the argument you're I'm sorry to draw you back to your retroactivity argument, but just so
Okay.
I understand it, your point is that we don't need to engage in this exercise about whether the statute is being applied retroactively or not because your claim was made after the statute became effective?
I'm saying that we didn't have a claim for attorney's fees until the claim for attorney's fees is under, and that's a brand new part of the statute. That's under Section F of 1343:14. The old F said the court shall order any claimant who fails to prove that he's totally innocent to pay the attorney's fees of anybody who's not totally innocent, which made no sense at all. But, I mean, it just made no sense. If there were two claimants and one loses and the other wins, why should the loser have to pay for the winner's attorney's fees incurred by the state? That made no sense. But the statute's been changed to say that the court may award reasonable attorney's fees, expenses, and damages for loss of use of the property to any claimant who substantially prevails by an adjudication on the merits of the claim. You know, we prevailed 100% on the merits of the claim. The money was given back.
I think we understand that, and we understand you want to use that language to support your client's claim and reverse the lower court's decision. The issue here is whether that statute can be applied, the new language can be applied.
Yeah, well, it's a prospective. My argument is, and I think it's pretty darn clear, that the prospective application is based upon the state filed its motion to dismiss on November 3rd, 2017. And that's well after the statute went into effect in August.
I just wanted to clarify what your position was.
All right. So I would ask you to look at the motion to dismiss that was filed by the state, because the state said in its motion to dismiss, the state does not believe it can meet its burden of proof at trial, and there is no good reason for the state to continue prosecuting the action. That's what they said November 3rd. I suggest to you that the same facts issued, the same facts were evident back in July 20th when the money was seized and they filed their notice of pending forfeiture. And it again was still the same set of facts when the complaint was filed on August 1st, which is just a week before, 8 days before the statute went into effect. They filed their complaint and made all sorts of allegations concerning my client's improper use of the money, or improper obtaining of the funds, and so what is the difference? Perhaps the prosecutor will get up here and explain to you what it was that was going through the mind of the people that seized the funds and filed the complaint at the time when they said this money was used for illegal activities. What changed between then and the time that the state filed its motion to dismiss? The only thing that changed was that we had a hearing, and the same two officers who wrote all of the reports testified at the hearing, whatever they testified to, and the judge found, well, there's no probable cause here. I mean, the judge didn't have any problem with that. There's no problem. Well, the state keeps wanting to say they won the hearing because they got past a directed verdict, but that doesn't make any sense at all. When the judge was placed in a position where he could make a decision, he decided that there was no probable cause. Since that time, nothing has changed, and maybe the prosecutor can tell you what changed between the time they first filed the complaint and the end. But it looks like I have a minute and a half left. I'll reserve.
Thank you, Your Honor. May it please the Court, my name is Joshua Smith. I represent the state of Arizona by and through the La Paz County Attorney's Office. I'm here today to ask this Court to deny the claimant's requested relief in his appeal and to affirm the trial court's order. First, I'm going to again renew the state's contention that this Court does not have jurisdiction to hear the appeal. The Cool Radiators decision, I believe, is directly on point. The reasoning of Cool Radiators applies directly to this case, and I would ask this Court to apply that logic to dismiss this appeal. And while this Court can always extend special action jurisdiction, even if it doesn't think it has appellate jurisdiction, I would argue that special action jurisdiction is inappropriate here. The legal issues implicated by a claimant's brief are adequately addressed in existing case law, and once you get past the retroactivity issue, the only issues that remain are contested factual issues that do not implicate issues of statewide importance. But even if this Court were to extend jurisdiction and hear this case, the Court should deny claimant's relief on the merits of the claim. Firstly, because claimant failed.
Why don't we have jurisdiction?
Under the Cool Radiators decision, it held that ARS Section 12-2101 provides no authority for the Court of Appeals to review an order awarding attorney's fees in connection with a dismissal without prejudice. This is an order denying a request for attorney's fees in connection with an order dismissing the case without prejudice. So it's an analogous situation. The reasoning from Cool Radiators, I would argue, applies squarely in this case. But even if this Court does believe it has jurisdiction, claimant's relief should be denied on the merits. Initially, claimant has effectively waived all of the issues presented in his appeal. He does not adequately brief any of the issues in his filings. And secondly, when you get to the merits of the case, he's not entitled to any relief. Claimant has to clear 3 hurdles to get any relief in this case. First, he has to establish that the revisions contained in HB 2477 apply retroactively to this case. First, claimant has effectively waived this issue. Claimant's argument is essentially that the statutes apply retroactively because it's a procedural change. He presents no analysis or argument as to why this is a procedural change instead of a substantive change in the law. His briefs don't address the Bolden v. Turek decision.
He also seems to say or said today that he's not asking for a retroactive application because he didn't ask for fees until after the statute was in effect. Is there an opportunity for a claimant to ask for fees before the point in time in the case that was requested in this case?
When this case was initiated, ARS 134314F did not specifically provide that
I understand that part, but his argument is that at the time he requested fees, the statute did provide for it.
At the time this case was initiated, he was not entitled to a request of attorney's fees.
But what about when he asked for it?
The state's contention is that the version of the statutes that were in effect when the case...
Got that too. But what I'm asking is there an opportunity for a claimant to request fees at an earlier time in the litigation than was done here? The forfeiture action is not exactly like a normal civil case. It has a notice which precedes other pleadings. So I'm just asking, in the forfeiture action, when does a claimant get to request fees?
I believe a claimant could request the fees under the current statutes when he files his claim. At the time the claim was filed, he was not entitled to a request for fees. The statutes...
He doesn't file the claim. The state files the claim, right?
The state files its notice of pending forfeiture asserting that the property is subject to forfeiture, and then the claimant files a claim asserting that the property is not subject to forfeiture under one of the statutory exemptions.
So maybe another question we had to look at is, when would the right to ask for fees accrue? Would it accrue as of the point of the illegal seizure, or would it accrue at the point in time where the state either acknowledges it can't meet its burden of proof, or the court dismisses the action because of the failure of proof?
I would say it would accrue at the time the action is initiated, Your Honor. The Bolden v. Turek decision specifically held that a statute that changes an award of attorney's fees is a substantive change in the law. Under Arizona case law, a forfeiture case begins when the state files its notice of pending forfeiture. Under the civil rules, a civil action begins when a complaint is filed. Both the notice of pending forfeiture...
There's a pretty significant distinction in how civil cases run and how civil forfeiture cases run. And it's often true that a plaintiff that fails to request fees in their complaint or at the inception of their appeal waives the right to ask for fees later. Is it your contention that under the new statute, let's say hypothetically we're in a situation where the forfeiture notice all occurred now, is it your contention that if a claimant failed to request fees at the point of their claim to the forfeiture funds, they would then waive the opportunity to request the fees from the court after the state acknowledged its faulty case?
Under the current version of the statutes, I would say that claimant's ability to request attorney's fees would be similar to any other civil defendant's ability to request attorney's fees. This case is a special case because everything that initiated this case was filed before HB 2477 took place, and then after HB 2477 became effective is when claimant filed his answer. I don't recall specifically if claimant asked for his attorney's fees in his claim. I know he requested for it in his answer and in most of his filings before the lower court requested fees. However, even assuming that HB 2477 applies retroactively, claimant has to also establish he substantially prevailed by an adjudication on the merits of his claim, and he does not establish that he did so because the merits of his claim were never implicated in this case. The only evidentiary hearing held was an order to show cause hearing. As claimant acknowledged before the lower court in his filings, the only issue for the order to show cause hearing that was held is whether the state then had probable cause to maintain its possession of the property. The merits of claimant's claim were never addressed. Judge Carlisle, in ruling from the bench, never ruled on claimant's claims. Judge Carlisle never said claimant proved his claims. Judge Carlisle specifically said that his ruling does not affect the remainder of the case. And after finding that there was no probable cause, he said that the parties would then need to begin filing their joint reports and scheduling orders. And if the merits of claimant...
You're saying you can proceed with a forfeiture where there was no probable cause for the seizure?
Under the statutes, I believe you can. The order to show cause hearing is analogous to a temporary restraining order, where if the state cannot establish it as probable cause, the property has to be returned to the claimant. That happened in this case. Ordinarily, if you couldn't establish probable cause, I would imagine that you would not be able to then go on and prove your case, though the way the statutes envision the order to show cause hearing, ordinarily it should be held closer in time to when the notice of pending forfeiture and the claim are filed. In this case, the order to show cause hearing was held 2 or 3 months after the notice of pending forfeiture and the complaint were filed because of conflicts. Judge Newman, the original judge, conflicted the case because of he had a conflict in the matter, and then Judge Carlisle, the initial hearing that he scheduled, had to be continued because of counter conflicts. But ordinarily, the statutes would envision the order to show cause being held very early on in the case. But here, there were no findings made about the merits of claimant's claim. Judge Carlisle said that the parties would need to file their joint reports and scheduling order, which would indicate that
I guess I'm still confused. Did you have some different evidence to proceed with this case that wasn't involved in the initial seizure, for which there apparently was no probable cause?
The initial seizure took...
Even if it's theoretically possible, you could have independently gathered some evidence that the claimant was dealing drugs or doing something illegal. I mean, in this case, you didn't have anything different, did you?
Given the timing of it, I did not anticipate any additional evidence coming to light, which was part of the reason why the motion to dismiss was filed.
The no probable cause determination throughout your case, right?
Yes, but that's distinct from the court finding that claimant established that his claim was valid, that the money was not subject to forfeiture. In the hearing, the evidence presented at the order to show cause hearing established that there was an odor of marijuana coming from the claimant's vehicle. There was no AMMA compliance. It's undisputed. Claimant was not transporting
the new
it.
statute, so you're focused on the first sentence that allows a court to award reasonable attorney's fees, et cetera, to a claimant who substantially prevails. The next sentence says, if the court finds that reasonable cause did not exist for the seizure for forfeiture, et cetera, or perhaps more relevant here, that the state intended to cause injury or was grossly negligent, the court shall award the claimant treble costs or damages. Is it possible to read those two provisions together to say that even if the court were to find that the claimant did not prevail, technically did not prevail on the merits because of the procedural posture of this case. The court could also find that reasonable cause did not exist, and in such case would be required to provide treble damages.
I believe so, Your Honor. My reading of the statutes is that the first part of it is just the award of fees following the forfeiture trial. The second part appears to be a second thing, but it requires two factual findings by the court. First, the court has to find that reasonable cause did not exist for the seizure for forfeiture or the filing of the notice of pending forfeiture complaint, information, or indictment, and that the seizing agency or attorney was intended to cause injury or was grossly negligent. So the trial court would have to make two factual findings before a claimant is entitled to an award of treble costs or damages. Judge Carlisle, in this case, did not make either required finding. Indeed, Judge Carlisle specifically said that he thought that it was reasonable at the time the property was seized for it to be subject to forfeiture. Again, the evidence showed that there was an odor of marijuana. There was no AMMA compliance. There's no dispute that the claimant was not transporting marijuana for the dispensary. There are specific regulations in place that specify how a dispensary agent can transport marijuana. That was not involved in this case. Claimant had no explanation for the currency, even though his claim was he sold the property a day before the seizure. He did not provide that information to law enforcement. The currency was packaged consistently with other money laundering cases Trooper Murray had been involved with. Claimant said he couldn't prove where the money came from, and he ended up disclaiming the currency. That was all the information available to the state when the forfeiture was filed. Judge Carlisle, when the money was seized, Judge Carlisle thought it was reasonable at that point for the money to be seized and be subject to forfeiture. The evidence claimant presented at the order show cause hearing was that he was only a bill of sale that he admitted he prepared specifically for the forfeiture case. He didn't have any evidence that corroborated the bill of sale. He didn't have any contemporaneous records for the alleged sales of the vehicle. His only corroborating witness, Judge Carlisle, commented that he did not believe that she was the most credible witness he had ever heard, So given all that together, claimant cannot establish that Judge Carlisle abused his discretion in failing to make the two required factual findings in order to be entitled to an award of treble costs or damages. And even assuming the merits of claimant's, or even assuming claimant prevailed by an adjudication on the merits of his claim, the award is still a discretionary award, and he cannot establish that Judge Carlisle abused his discretion. And again, claimant has effectively waived this issue on his appeal. In his briefs, he makes no reference to an abuse of discretion. He cites the no case law addressing abuse of discretion. He presents no argument at all that Judge Carlisle's ruling was unreasonable or capricious or otherwise unsupported by the evidence. Claimant's entire argument is effectively it's not fair that he wasn't awarded his attorney's fees, but that's not an abuse of discretion. He has to establish that there was no reasonable basis at all for Judge Carlisle's ruling, and he cannot do that, and in fact fails to do that. And because he fails to establish an abuse of discretion, he's not entitled to any relief, because ultimately, if this court were to conclude the statutes apply retroactively, and if this court were to conclude that claimant prevailed by an adjudication on the merits of his claim, this court would still have to find an abuse of discretion for the denial of his request, the award of attorney's fees. And claimant fails to establish there's an abuse of discretion here.
Can we go back to the question I started with? And you've said that your position is that the earliest opportunity that a claimant could request fees would be in the answer to the complaint. First, was the answer to the complaint in this case before or after the effective date of this statute?
I believe, Your Honor, I said that the earliest would be when they could file their claim. The answer in this case was filed after the effective date of HB 2477. The legislative history, which is included in the appendix to the state's brief, makes it clear that HB 2477 was to take effect on August the 9th of 2017. There's nothing in the language of the statute that says that it's to apply retroactively. This case was initiated before the effective dates.
Right, I know all that, but so do you have a position as to when a claimant is required to request fees? What provision is applicable here?
Again, Your Honor, I would treat it in, assuming that we're in a case where initiated after August 9th of 2017, I would treat it analogously to any other civil action where a defendant requests an award of fees. I believe that would be with their first response to pleading. And here, claimant is not entitled to an award of fees because the version of ARS 1343-14F that was in effect when this case was initiated.
You keep saying that. I understand that's your position, but I'm exploring the appellant's position, which is that what matters is when his entitlement or the availability of fees accrued or became available to him. And so that might depend on when he could have made a fee claim, or perhaps when he did make a fee claim, which I think is the appellant's position.
Yes, Your Honor.
I mean, again, a forfeiture action is not exactly like a civil claim. It's a little weird.
I would agree with that assessment, Your
And
Honor.
I mean, there's something to the appellant's argument that the way they're structured is procedurally very, very odd, presents numerous obstacles to a claimant. I remember ruling for a claimant and reinstating his claim, after which he failed to make it through the subsequent hurdles. I mean, it's not straightforward like a complaint in a civil action with an answer, and then you have disclosure statements and discovery and a pretrial statement and a trial. It's not like that.
Well, Your Honor, I would like to. The question you pose is complicated.
Yeah.
For the facts of this case, because when this case was initiated, claimant had no right for a claim of attorney's fees. A retroactive.
Know whether he did or not. I mean, until you have a hearing, how does he know what proof you've got? And when he has the hearing, and the judge says, "Well, you don't even have probable cause," then he says, "Well, if you don't have probable cause, then my client has a right to fees."
Well, the purpose of the order show cause hearing is to allow a claimant early on in litigation to, require this. It's analogous to a preliminary hearing in a criminal case or a temporary restraining order. It's to require the state to prove that they have grounds to maintain possession of the property pending the forfeiture case, and thereby justifying depriving the claimant of his property. In this case, the order show cause hearing was held later in time than is contemplated by the statutes. Ordinarily, it would be fairly early on, which is why I analogize it to a preliminary hearing in a criminal case, where typically at a preliminary hearing in a criminal case, at best you would have the police reports for some of the officers involved in the investigation. And this case just happened due to delays be held a couple months after the fact when the parties had an opportunity to engage in discovery. The state's contention is that the statutes do not apply retroactively. When this case was initiated, claimant did not have a request for attorney's fees. Applying the statute retroactively would effectively deprive the state of a substantive right to not be subjected to attorney's fees that the state had a vested interest in when this case was initiated. I would refer the court to Hall v. A&R Freight Systems, which is the citation is 149, ARS 130, the Supreme Court decision from 1986. That case held that a substantive right may not be impaired once they vest, and a right vests when it's assertable as a legal cause of action. When the case filed this action, it had a vested right to not be subjected to an award of attorney's fees, to allow the claimant to now be...
Is there no provision like frivolous action that could have caused you to be liable for fees? I mean, I'm not saying it was frivolous, but there are other provisions out there, aren't there, that...
The remedy for the order to show cause hearing is the return of the property. The property was returned to claimant in this case, and the case was promptly dismissed following the order to show cause hearing. The forfeiture process worked the way it should have worked in this case. The state still maintains that, given what it had, that it had probable cause to proceed. Judge Carlisle's ruling that there was no probable cause to maintain possession of the property does not mean that the claimant is entitled to an award of attorney's fees.
I guess I'm just suggesting that it may not have been the case that when you filed the notice of forfeiture that the state was free to be unconcerned that they would ever have to pay fees, because if they brought a groundless forfeiture, I assume they could be on the hook for fees.
Well, Your Honor, in answer...
I'm not quite saying that the ruling from the order to show cause meant that in this case it was a frivolous or groundless action. I'm not saying that. But a state who brings a groundless forfeiture action, I imagine, was subject to the possibility of paying fees to a claimant who has to go to court to get his money back.
And Your Honor, my time is run, but I can refer the court to another provision or subsection of 1343-14E that was in place prior to the enactment of HB 2477, and I included the Senate engrossed version of HB 2477 as a part of my appendix, which will show the prior versions of statutes with the changes. ARS 1343-14E, that was in effect when this case was initiated. Part of it provides that if it appears that there was reasonable cause for the seizure or forfeiture, or if they're filing notice of pending forfeiture or complaints, and the claimant is not in such a case entitled to costs or damages. So, under the prior version of 1343-14F, it did not specifically provide that a
I
claimant...
think Judge Thompson was referring to something potentially outside the forfeiture
Right.
statutes.
I don't...
Thank you for the
I don't know off the top of my head if ARS, that provision would apply to the forfeiture case, Your Honor. I believe my time is up. Thank you.
I can answer your question, Judge Thompson, simply. If you look at the statute that was in effect both before 1343-10, which is the statute that you use in order to get the order to show cause hearing, it said under Section J, no person claiming to be an owner or an interest holder in property seized for forfeiture under this chapter may commence or maintain any action against the state concerning the validity of the alleged interest other than as provided in this chapter. And that's been interpreted. I've done a lot of these forfeiture cases. That's been interpreted uniformly to mean you're not entitled to attorney's fees. You're not entitled to even request them. And I didn't until it became apparent that there was no basis for the claim at all.
And does 4310 still exist, or is it?
Yeah, that statute still exists. It hasn't. That portion was not removed from the amendment.
So in other words, the only ability of a claimant to get, even under the new law, the current law, to get fees is via the forfeiture statute, that subsection F.
I believe so.
Once they make those
Before
choices.
there was no provision for a claimant.
Oh, the provision was exactly the opposite. You can't have attorney's fees under the old statute. And I think what the state is saying is that I should have requested them. You know, there's no provision for them. You just simply can't have them.
Yeah, I think the state's saying that because they filed before this went into effect, you couldn't request them.
Well, that's what they're saying, but that's not what happened. What happened was the state's case completely fell apart, and what we didn't hear is any basis upon which this gentleman right here is the one who determined probable cause. And he stands up here and tells you, well, I think we still have probable cause. They didn't have anything. Judge Carlisle, in passing, said, well, you know, it appears as though your client signed a waiver. He was told by the officer it was 102 degrees out on the side of the interstate, and the officer pulls the guy over and says to him, I'm going to take you to jail. The guy says, I don't want to go to jail. He says, well, then here, sign this. That's what you're going to...
Waiver of his money?
Giving him the money, saying, yeah, it says they have a form. DPS has a form that says, I hereby, and you just put in the amount of money that you're giving up. They do this all the time. It's horrible. But it sure seems to me that you can't make the decision as to whether there's any attorney's fees are going to be awarded. I think you need to send it back to Judge Carlisle. I asked him, and I tried to get him to say what the basis of his denial of the claim was, and he just wouldn't respond and just issued the minute entry, denied any further argument on it. I think he needs to be asked the question, did they really have a case here? And
Thank you. We
thank you.
appreciate your arguments.
Thank you, Your Honor.
We will take the matter under advisement, and we're going to take a brief recess to prepare the courtroom for the next case.